Welcome back. You're watching Your World at 10. Now, earlier today, the Supreme Court heard Ratan Tata's plea to protect his privacy following the release of the Neera Radia tapes, or in fact, should I say, the leak of those tapes. The court was critical of the media coverage in that hearing today, saying care should be taken to protect the image of individuals till the hearing of the privacy suit is completed. Ashok Bagaria now joins us with details of what happened in court today. He was our reporter on location. Ashok.
Well, actually, the Supreme Court was very critical of the media reporting in this matter, and not only this matter, but even in the 2G spectrum case. And in fact, the Supreme Court has warned and advised the media to show restraint and said, please don't cross the Lakshman Rekha while reporting court proceedings. But besides that, as far as the Ratan Tata case is concerned, the court has said that as far as the dignity of an individual is concerned, it should be protected and it should not be sullied without any evidence. So these were two pieces of advice for the media by the Supreme Court today. But besides that, in this particular matter, the court has asked the Attorney General of India, who was representing the central government, to give it a copy of the complaint which was received by the finance minister, and on the basis of which the Neera Radia phones were tapped. So now the Attorney General will have to give a copy of that complaint to the Supreme Court in a sealed envelope. But besides that, the court has also asked Tata's counsel to file additional documents if he wants by the first week of January, and the court has listed this matter for next hearing on the 2nd of February.
Alright, Ashok, many thanks for that update on what transpired in court today. We're now joined by senior Supreme Court advocate Prashant Bhushan, who has filed an intervention in that Tata petition. Mr. Bhushan, welcome back on Your World at 10. Thank you for your time. Let me ask you for what you make of the proceedings in court today. And the second part of that question would be that, considering the frequency with which tapes are getting leaked, and I point to the fact that a new set of tapes was apparently made available to some sections of the media as recently as Friday and Saturday and across the weekend, that this hearing will now continue on the 2nd of February. Does that mean that it offers absolutely no relief whatsoever?
Well, I don't think it offers any relief to Mr. Tata. Of course, the court's observation that the media should be careful about tarnishing the reputation of individuals was more in the context of inaccurate reporting of court proceedings. They referred to a question that they had asked about the Home Secretary's statement about the Radia tapes, which have so far been aired, being only the tip of the iceberg. And they mentioned that some media channel had reported that they had rapped the Home Secretary, which they said was incorrect reporting, and that this kind of reporting tarnishes the reputation of individuals. So far as the Tata petition is concerned, Tata did not even, the lawyers for Tata did not seek any restraint on the media, nor is there any restraint on the media. Of course, the media has been advised to be careful and not unnecessarily tarnish the reputation of individuals.
I get that, sir, but what is your comment on the fact that I would imagine that whatever relief the Tatas would want would in some sense be immediate relief to some extent, because you definitely don't want, I would think, more tapes to be out there if you have an objection to the fact that the existing set of tapes is, is in a breach of your privacy. So now that this next hearing will only happen in February, which is 2 months away, what does it mean for the ability of an individual in this country to be able to seek the right to privacy or protect his privacy?
You see, firstly, that the Tata tapes or the Radia tapes which have so far come out in the public domain are not really, do not contain any personal conversations. Even the conversations of Tata with Ms. Radia are not really personal in nature, though there might be 1 or 2 snippets which are personal in nature, but they are hardly of a nature which invade his privacy. The law on this is well settled in India as well as in the US, where even on the question of the leakage of the Pentagon papers, when the US government wanted a restraint on the media to carry the Pentagon papers, which they said had security implications which would compromise US security, the US Supreme Court held that no, they can't be restrained. There cannot be any gag order on the media that would go totally against the freedom of speech or the First Amendment as it is called in the US. The law on this is that, well, you don't gag the media, though the media would be well advised to be careful so that they don't air conversations which are private in nature, don't invade the privacy of individuals, don't defame individuals, because otherwise they'll be liable to be sued for damages and even for criminal defamation if there has been any defamation of individuals.
So in fact, I understand that the Tata case, again, like you pointed out, they are not seeking an injunction against the release of the tapes, nor are they seeking to gag the media. The question they seem to be asking is, where does the freedom of the press stop and the right to privacy for an individual begin, so to speak? Now, how do you weigh that argument? Also the fact that they claim, or they could be claiming in their petition, that the tapes are government property. When government property is leaked, so to speak, it tantamounts to stolen property, and therefore the publishing of such stolen property is definitely a violation.
No, I think that's not really an issue of stolen property, etc. The issue is really what are how does one balance the right to privacy with the public interest involved in the people knowing about the contents of these conversations, which are clearly conversations which show you how government policy, government decisions, parliament discussions are being manipulated, influenced, maneuvered by some industrial lobbies through paid professional lobbyists. Now, this issue actually has been settled by the Right to Information Act, which gives an exemption for privacy, but the exemption is couched in a very conditional manner. It says personal information which has no relationship to public interest or activity, or information which will cause unwarranted invasion of privacy unless the public interest involved in the disclosure of that information outweighs the interest of privacy. Therefore, in either case, the interest of privacy is overridden by the public interest involved in the disclosure. In this case, the nature of conversations of Ms. Radia are clearly of great and immense public interest because it shows you the working of important institutions of the country, and therefore the public interest would clearly override any minor interest of privacy, though as I said, there is hardly anything private or personal in these conversations. These are all professional conversations.
That is a matter of interpretation, sir. Several of those conversations are personal. Several of them are gossipy in nature, and just the very fact that they're out could mean that other people's reputation is now at threat for absolutely no reason at all. Two people sitting and talking about a third person in a derogatory fashion. So I won't get into that because that's exactly what's in front of this court. But I will ask you if the court has inquired with the government. I know they've asked them to file the complaint on the basis of which these phones were tapped. But did the government make any more information available on where that complaint came from? Was it anonymous? Was it not anonymous? And what led the government to take as severe a step as phone tapping?
No, the court only asked the government to give them in a sealed cover the letter or the information on the basis of which Ms. Radia's phones were tapped. So that would be provided by the government to the court.
Mr. Bhushan, I believe that along with your father, Senior Mr. Bhushan, today you filed another petition asking for the publishing of all 5,800 odd conversations that are part of those phone taps. Is that correct? And what is the purpose that you hope to achieve, considering that the government or the Supreme Court is already looking at the matter of privacy in the selective publishing of these tapes?
Yes, we have proactively sought the disclosure of this information because the tapes that have been published so far contain information of enormous public interest. In fact, they are clearly covered by what the Supreme Court has laid down as the people's right to know about the working of all public authorities and public institutions. Clearly, these conversations shed very important light on the working of government institutions and public authorities in this country, and therefore the people of this country have a right to know them. And therefore we have said that you to appoint some committee which can examine these conversations, remove the ones which are personal or essentially personal in nature, remove any others which would qualify for any exemption under the Right to Information Act, and publish the rest and make them available in the public domain, because the people have a right to know this.
All right, Mr. Bhushan, thank you very much for joining us with that information. This case now continues hearing on the 2nd of February, as Ashok told us earlier today, and will ultimately result in determining where the balance between the freedom of press and the right to individual privacy lies. It will be a landmark decision, whichever way it goes. Meanwhile, here's the first vocal outburst against the tapping of Neera Radia's phones, or the tapping of phones, if I may say so. It comes in from Deepak, Parekh, who made this comment earlier today.
I personally think it's an invasion of privacy. Unless the department or the organization, that is a government organization which is tapping someone's phone, has enough proof that, or enough suspicion that either tax is evaded or hawala transactions are being done, or the country is losing lakhs of rupees on revenue through whether it's customs, excise, whatever, then one could tap someone's phone, but the tapping permission must be given by the highest authority. And phones cannot be tapped or lines cannot be tapped by anyone in the income tax department. It has to go to the highest level.